position. Your client does not want to go through an elaborate discovery process and wants to obtain documents from this person across state lines. Under the rules of court, lawyers can prepare and serve their own third-party subpoenas within the state, but out of state, as we know, those subpoenas are not enforceable. So the question presented is, may you send such a subpoena ducis tecum, to the out-of-state witness in the hope that he or she will produce the requested documents? So the question's out there. How many people say, yes, you can do that? How many people say, no, you can't do that? Why is there a problem with sending a subpoena out there? If it's not enforceable, it's not enforceable. It's no big deal. What does a subpoena do? What does it contain? It contains language that says you are hereby commanded to appear, and that in the content of some subpoenas, that the failure to do so, you may be judged in contempt of court. In other words, you have the appearance of enforceability, the appearance of consequences that might occur if that witness does not obey the subpoena. Would it be different if you had to, if the witness agreed to accept service and sign the subpoena and give it back? Would that cure the ethics issue? What is the ethics issue? Deception? The appearance of deception, the appearance of enforceability when it's not. Rule 8.4, C, the rules, Virginia Rules of Professional Conduct tell us that a lawyer may not engage in conduct that is deceptive or make misrepresentations that reflect adversely on their fitness to practice law. Suppose you took that language out of the subpoena and it didn't command, and you could edit it and redact all the official language, and then you call the witness up and say, I'm going to send this to you, and you know, I'd like for you to accept service and produce the documents. Would that be okay? How many people think that would be okay? How many people still think it's not okay? All right. What? Will somebody tell me why they think it's still not okay?
You got to sign your name to it.
You got to sign your name to the subpoena.
Correct.
True.
Still deceptive. Unless you tell them this, when you send the subpoena to them, you tell them that it's not enforceable.
Right. You got to tell them.
Yes, that's.
You would have to tell the witness that that subpoena is not enforceable, even if they accept service, even if you strip out the language, because in all likelihood, particularly lay witnesses are going to make an assumption that the subpoena has enforceability or compulsion of law, and you need to correct that misapprehension. If you do that, then it would be okay. Hypothetical number 2. Your local federal court appointed you to represent a criminal defendant. Your client wants to appeal his recent conviction and insists that you pursue every possible argument, including some arguments that you believe have no merit. May you include in an appeal of a criminal conviction arguments that lack any factual support? May you do that as a criminal defense attorney?
No.
No. Anybody think that you can? All right. Show of hands. How many people say you cannot do that? How many people say that you can? there lies an issue here, and here is the tension. We're governed by the rules of professional conduct, and Rule 3.1 deals with frivolous claims. And Rule 3.1 tells us that a lawyer may not file a suit, assert a claim, interpose a defense, assert a position, make an argument, or take any other action on behalf of the client that is frivolous. So the general belief is that as lawyers, when we represent clients in court, we can only present non-frivolous arguments or non-frivolous positions. That doesn't mean it has to be a winner. It simply means that it has to have some basis in fact or law. It doesn't mean that you're going to prevail on that issue. And so even if you have considerable doubt as to the merits, it may still be a non-frivolous argument. That's the first point. The second point is that you have to balance your ethical obligations as an attorney against some constitutional considerations under the Fifth and Sixth Amendments. And under those amendments to the Constitution, a criminal defendant has a right to an appeal and has the right to effective assistance of counsel. The United States Supreme Court in the 1967 case in Anders versus California indicated that when it comes to balancing the lawyer's professional obligations not to assert a frivolous claim against the defendant's procedural rights to an appeal, that the constitutional rights will trump the lawyer's ethical obligation. Under those circumstances, then it is possible for a lawyer to file an appeal of a criminal conviction, asserting arguments and making points that do not have merit and may even be frivolous. And the comments to Rule 3.1 make an exception for criminal defense. By way of another example, that is why criminal defense counsel who know that their client is guilty because their client has acknowledged guilt may nevertheless counter the elements of the Commonwealth attorney's case and require the government to prove each and every element of their crime. And also, because of the Constitution, may enter a plea of not guilty, even though they know that might not be the case. Similar concepts apply here with regard to criminal appeals. Now, this doesn't apply to civil appeals. This only applies in criminal cases. Hypothetical number 3, another criminal law situation. You devote several hundred hours each year to your state's capital murder pro bono project. At one meeting with the client, he expressed tremendous regret for the murder he admits committing. He wants you to forgo putting on a defense saying that he deserves to die. This client seems to be increasingly confused, and so you have doubts about his competence to make these decisions. May you honor the client's request under these circumstances? Should you honor the client's request under these circumstances and not put on a defense or exonerating evidence? Or do you disregard the client's direction and proceed in what you believe to be the client's best interest? How many people would pick the last course of action? What's that?
Proceed.
Yeah, proceed putting on the evidence in spite of the client's direction.
In the first question, is he competent?
That is the first question, isn't it? Because in the hypothetical, you're to assume that the client is having difficulty making decisions. If he's incompetent, he can't make any decisions at all. Truly incompetent. And then Rule 1.14 comes into play. Rule 1.14 is one of the rules of conduct that says that if the client suffers from impairment or diminished capacity, the lawyer must act in the best interest of the client and take measures reasonably necessary to protect the client. So in addressing this problem, in theory, if the client were truly competent, and in a lot of death row cases, at least the capital defenders will tell you that they really have substantial concerns about the competency of their clients. But assuming that they were competent, you would be obligated to abide by their decision. It's only because they are suffering from a diminished capacity or lack of competency to make those decisions that you would be in a position to disregard the client's decision. In fact, some courts, and Tom has cited these cases in your materials, which, by the way, when you go out, make sure that you pick up the materials, because the so-called correct answers to these questions are in those materials, and Tom has taken a great deal of time. He cited a number of cases that have ruled that death row inmates do have the right to direct the lawyers not to present exonerating evidence. And the ethics rules point to that also as well. If you look at Rule 1.2 regarding scope of the representation, the decision to plead guilty, the decision to appeal, the decision to settle the case, ordinarily, not ordinarily, always belongs to the client, except in circumstances in which the client is unable to make those decisions. And that doesn't mean that even then that the lawyer doesn't get to make that decision, but usually what is expected of the lawyer is to use a judicial process to have someone appointed to represent the defendant that can make those decisions for the defendant, because those decisions do not belong to the lawyer. They belong to the client, and the rule is very clear. Lawyers who settle cases without the client's authority, pleading guilty, without authority, waiving a jury trial, without the client's express authority, are violating Rule 1.2. And so there have been a number of cases that have gone both directions on this issue, but the key issue is turned upon the competency of the client. We turn now to hypothetical number 4. Ghostwriting. Ghostwriting pleadings. If there's a question, feel free to interrupt. Yes?
Does the attorney have to make that determination of competency himself or herself?
I don't see how the attorney can. That's the question Jack asked. Does the attorney have to make that decision of competency? And the answer is, well, no, I don't think the attorney can make that decision. What the attorney can do, and what Rule 1.14 allows the attorney to do ethically, is to seek the assistance of others to evaluate the competency of the client. In capital cases, death cases, there are usually funds with which to have an evaluation done. But you also have to recognize that there's varying degrees of competency. And for example, just because the state's forensic psychiatrist says that your client is competent to stand trial, doesn't mean that they're not still suffering from mental impairment that affects their decision-making capability and their ability to participate meaningfully in your defense of that client. And so they're different standards, and you need to be aware of that. Hypothetical number 4, on ghostwriting. One of your sorority sisters has lost her job and wants to pursue a wrongful termination claim. Your firm would probably not want you to represent the plaintiff in a case like this. Doesn't sound like a very good idea. Although you do not have any conflicts. You offer to help your sorority sister as much as you can. So the question is, without telling the court and without informing anyone else, can you draft an initial complaint or a lawsuit to help this person file pro se? I see lots of people nodding their head no, and that is the best answer to this question, but it is worthy of some discussion about and changing the facts a little bit. But first, let me say that the courts, in particular, have been more restrictive on allowing lawyers, or actually prohibiting lawyers from ghostwriting pleadings than the bar opinions have. In 2007, the ABA issued an opinion overruling and completely reversing its prior opinion, saying that it is no longer unethical for a lawyer to assist a pro se litigant by ghostwriting a pleading, and the lawyer does not have to disclose either the fact that the pro se litigant has received substantial assistance from the attorney, and they do not have to identify the attorney who assisted in the preparation. I would not take that position in the Eastern District. I haven't read any opinions in the Western District of Virginia, but in Virginia, as far as I can tell, both by our ethics opinions, LEO 1592, and the Eastern District cases that I've looked at, 3 different decisions, one by Judge Morgan, that I recall, in which the court issued a show cause and had the attorneys appear in court that drafted these pleadings to show cause why they should not be held in contempt and for violating Rule 11. Interestingly, the ABA takes the position that Rule 11 isn't violated because the attorney has not signed any pleading and is not making any, there are no misrepresentations being made to the court. The ethics opinion 1592 says that it's unethical because it's deceptive conduct to allow a pro se litigant to use a pleading that you prepared without disclosing that that lawyer had received substantial assistance from an attorney. And some of the bars and some of the courts have moderated a little bit on the ghostwriting issue. I've had ethics calls frequently about ghostwriting, and I cite them to the opinions. But it's my belief that if the attorney discloses or makes sure that the court and opposing counsel is aware that the pro se litigant receives substantial assistance from an attorney, then there's no fraud on the court. But it would be the attorney's obligation to make sure that that fact got communicated to the court and cannot rely on the pro se litigant to carry the water for them. They need to make sure that they do that. The second question is whether the attorney has to sign the document, and the answer that I've given from an ethics perspective is that they do not need to sign the document or disclose their identity if they have made sure that the court is informed. Some jurisdictions require the attorney to file a letter with the court indicating that they assisted with the preparation of that pleading. And that may or may not be the answer, but it's clear that if you're contemplating ghostwriting either in Virginia or elsewhere, you need to look closely, not just at the bar opinions, but at the court opinions that have been issued on this subject, because it seems to me that the bar and the court have reached different conclusions on this issue. Filing claims. This is hypothetical number 5, filing claims subject to an affirmative defense. Now this is a question that I have never been asked by anyone in all the years that I've worked at the bar, and that is whether or not it's ethical for a lawyer to file a time-barred claim, a claim that is barred by the statute of limitations. but it's in every professional responsibility course book, and it's an NPRE exam question. And the answer that they give is it ethical or unethical? How many people say you can file a time-barred claim? How many people say you cannot? The reason why you would argue that you cannot is that you're pursuing a lawsuit that is frivolous or would be viewed as frivolous because it would be subject to dismissal. The uniform answer, every bar opinion issued on this subject, unanimously agreed. I've read no opinion saying otherwise, and Tom cites legions of them in the materials, is that it's ethical to file a lawsuit even though the claim is time-barred. There's a Virginia Legal Ethics Opinion 491. It's an ABA formal opinion 387. Again, you don't need to write any of these sites down or these rules. These are all in the written materials. There is one interesting case, though, and this really throws a fly in the ointment, and that's the case of Brubaker versus City of Richmond. The district court imposed Rule 11 sanctions on plaintiffs and plaintiffs' counsel for filing a defamation case after the one-year statute of limitations had expired. The court ruled that the cat and mouse game of filing a suit to find out whether or not your adversary is going to interpose an affirmative defense does not satisfy the lawyer's obligations under Rule 11, and the Fourth Circuit affirmed the district court in Brubaker. So that case stands in stark contrast to the bar opinions on the same issue, but that's Rule 11, and Rule 11 and Rule 3.1, other rules of conduct, are different bodies of law, and you get some different results.
Could there be an issue here that the alleged victim here, the client, discovers many years later that he has a problem with his direction? Would that get around?
I'm sorry, he had a problem. The client discovers what?
That the discovery of his injury is the time at which he marked the statute of limitations time from. Could you argue that? I think you can, but I'm not certain.
The question is whether the answer changes when the client has, not until many years after the actual injury, discovered that they were injured. That is what we've been taught in tort law as a discovery rule. In Virginia, there are some types of claims that are subject to a discovery rule, claims arising out of exposure to asbestos, mesothelioma. That would be a classic case where the injured victim would not find out until long after they had sustained an actual injury, and the statute of limitations would not run until the date of discovery. But that's a legal issue, not an ethics issue, and as long as the lawyer has a reasonably good argument for asserting the position that the suit is timely because of a discovery rule, or arguing, as the plaintiffs did in the Locke case, Locke versus Johns Mansfield, the plaintiffs argued a good faith argument for the modification or extension of existing law, saying, look, the date of injury rule is too harsh of a rule to apply in these types of latent exposure cases. So that would be an ethical argument. That would be an argument that could be properly made, even though the claim was time barred under existing law, that you're making a good faith argument that there needs to be a discovery rule in these types of cases. The next issue is something that comes up more frequently under family law. How many people do collaborative lawyering? Any collaborative lawyers out there? Let me explain what I think a collaborative lawyer is, and maybe you've been involved in there's a growing form of alternative dispute resolution called collaborative law, in which a lawyer and their client will reach a four-way agreement with the opposing counsel and the opposing party, in which they agree to work out their dispute. Like mediation, to bring the parties together and try to see if they can reach an agreement. Except in collaborative law, there's no third party neutral. There's no mediator that is there. It's just the lawyer and their respective clients trying to reach an agreement, like a settlement conference, where with the lawyers and the clients both present. But here's the key factor, and it's in your hypothetical. If the negotiations fail, both lawyers would agree to withdraw from representing their clients, and their clients would have to hire new counsel if they couldn't reach an agreement and would have to litigate. They would have to start from scratch. So the question is it ethical for a lawyer to enter into this type of agreement, this four-way agreement, in which the parties have committed to writing, not the other things that they commit to writing too, which are quite interesting, but the key component is the requirement that the lawyers have to withdraw if the parties cannot reach an agreement, and they've got to get new counsel. So, how many folks think that passes muster under the rules of professional conduct? How many people think it does not? There are some bar opinions that say that the Colorado bar issued an opinion several years ago saying collaborative lawyering created a conflict of interest. It created a conflict of interest because if the lawyers have to withdraw, then they are materially limited in how they can perform in negotiations, because there's no threat. That lawyer presents no threat. It really dampens or mutes their advocacy in settlement negotiations. I'm not saying that negotiations need to be adversarial, but come on, there's advocacy in settlement negotiations, and this could have a dampening effect. But Colorado seems to be the only bar opinion out there that says that it's unethical. All the other states that have considered collaborative lawyering have addressed it this way. And here's how the rationale goes. The lawyer and the client have the right to limit the scope of the representation. If a client wants to hire you solely for the purposes of negotiating a settlement, and that's all they want you to do, you can agree to do that, as long as you disclose to the client and have a clear understanding up front regarding the responsibilities, what the risks and advantages are to the lawyer having to bail out if the negotiations fail. But as long as there's been informed consent, Rule 1.2 allows the parties to restrict the scope of representation, and it's proper. What gets a little dicey in collaborative law, though, is that there are covenants of full disclosure. And when we move later and talk about settlement negotiations and ethics, the theme that will come out of that discussion is that you don't have to volunteer information to the other side and educate them, except under very limited circumstances, that you and your client can withhold information in settlement. In fact, that's one of the reasons why clients would want you to negotiate settlement, because they don't want to go to court and have a public trial and air out all the dirty laundry. So the problem occurs, and where a conflict may arise in collaborative law is where the client is not forthcoming with information after you and the client have agreed in this four-way agreement to be forthcoming and make full disclosure. Because collaborative law does not work unless there's full disclosure. It's used a lot in family law. But the bottom line is, and I think Tom's right, and I agree with Tom, that provided that there is informed consent and proper disclosure of the risks and advantages to using this form of alternative dispute resolution, it's not improper under the rules of professional conduct. Any questions about collaborative law? Now, who wants to raise their hand and say they do? All right. The hypothetical number 7. We're dealing with a situation involving a neighbor who is pursuing litigation against a local tree surgeon who accidentally damaged the neighbor's house while attempting to cut down a tree. This should be done by professionals only. The tree surgeon has chosen to represent himself. Your neighbor and the tree surgeon have worked out a settlement which must be endorsed by the parties and entered by the court. May you prepare a settlement order and present it to the unrepresented tree surgeon for his signature? Yes or no? How many people say yes? How many people say no? If people said no, there wouldn't be any way to resolve the case. So I think the answer is fairly clear that we can do this. But there are some caveats. And the rule that comes into play here is Rule 4.3. Rule 4.3 tells us that when a lawyer is dealing with an unrepresented person, the lawyer has an obligation to make sure that the unrepresented person does not misunderstand the lawyer's role. It's important that the lawyer make sure that the unrepresented person understands that you're representing the client and the client only, that you do not represent them, that this document, if they sign it, binds them to an agreement, and that they ought to consider consulting with the lawyer before they execute that agreement. As long as those caveats are fulfilled, there's nothing improper about presenting an agreed order or a contract or of any sort to reach a settlement agreement on a case. Lawyers have to be able to deal with people who choose not to be represented by counsel. Okay, now we come to the fun part of the presentation, and that is settlement negotiations. And we're going to assume, let's assume for purposes of these next hypotheticals that we're not in court yet. Because in some circumstances the answers would be quite different if you were in litigation as opposed to trying to settle a case before any litigation has been started. So you are preparing for settlement negotiations, and you have proposed several questions to a partner whose judgment you trust. First question is, may you advise the adversary that you think your case is worth $250,000, although you really believe the case is only worth $175,000. How many people say you can do that? Lawyers do that all the time. That doesn't make it right just because lawyers do it all the time. But lawyers do it all the time. What we're talking about is Rule 4.1, and that is fairness in dealing with third parties. Rule 4.1 tells us that a lawyer may not make an affirmative statement of law or fact that is misleading, a material statement of fact or law. So The question really turns on whether or not statements or opinions or expressions as to the values of cases constitute a material fact that would make it a misrepresentation under Rule 4.1. And the answer is that these are sometimes referred to as statements called puffing, exaggeration. Lawyers use other negotiating tools also. For example, when lawyers negotiate, they may place matters that are at issue that they don't really care about. The reason why they want to do that is so they can give those things up and throw a bone to the other side. But they didn't really care about those issues, but they acted like they cared. It's called bluffing. And statements of value regarding the cases fall under a comment. Comment 2 to Rule 4.1 says that in conventions of settlement, opinions or statements regarding the values of cases or the client's intention to settle are not material statements of fact and therefore do not violate this rule. Let's take another question. May you argue to the adversary that a recent case decided by your state Supreme Court supports your position, although you honestly believe that it does not? The case that you assert, this case stands for Proposition X, but you honestly believe that it does not. Can you make that type of statement in a negotiations environment? How many people think you can do that? How many people think you could not do that? More people say you cannot. Tom offers the unequivocal answer of maybe. I think that it depends. It depends on the materiality of the case, the issue being presented, the sophistication of the parties, the ready access that your adversary has to discern what the applicable law is. But generally, I would avoid misrepresenting what cases say in any environment, including the settlement negotiations environment. I don't think that the fact that you're in settlement opens the doors for that type of statement, and trying to pigeonhole it under Comment 2's exception as permissible puffing, I think is stretching the comment perhaps a little too far. Rule 4.1 tells us that generally you're not under an obligation to inform the opposing side even of material facts, particularly, especially if they have the means to obtain those facts and discover the law on their own. It's not your responsibility to educate the other side. But the point is that you can't mislead your adversary by making statements that are in violation of the rule. How about this question? The client says the client will accept anything less than $100,000, and the opposing counsel would ask if your client will accept $90,000. Can you say no? Because you want to look good with your client and you impress the client, so you want to say no. Are you in violation of 4.1 if you say no? How many people think that is a misrepresentation? How many people think that that's not a misrepresentation under 4.1 and Comment 2 that I've described to you? Okay, how many people are on the fence? Tom's answer to this question is maybe. And I think that the reason why Tom says that is that the answer is not that clear. When you get away from expressions of value, the Rule 4.2 Comment 2 says that the client's intent to settle is a statement that does not have to be factually correct. So if you look to comment 2, the answer would seem to be that you could get away with saying this. I don't think that that's a good idea, but I do think that there is room and that the comment to 4.2 is squishy enough that you would be able to make that representation. While we're talking about this, let me make one other point. I'm supposed to be talking not only about ethics, but also about professionalism. So keep in the back of your mind that when I'm talking about ethics, I'm talking about the lowest behavior, which is acceptable, and that a violation of the rule is really, striking below that standard, below that level. As a professional, you should be able to figure out a way to conduct your negotiations in a way that you don't encounter these problems and do not even come close to the wire in regard to making a material misstatement of fact or law in settlement negotiations. Now, hypothetical number 9. This is about silence about the law, whether or not you can be quiet when your adversary doesn't know something. You are preparing to begin a serious settlement negotiation with a plaintiff's lawyer and have several questions about whether you can stay silent in certain circumstances that you expect may arise. So this is going to be different from the other hypotheticals where you're making statements. You're not saying anything under these circumstances. May you remain silent if the plaintiff's lawyer tells you he realizes that the plaintiff's available damages are capped at $250,000 by a state statute, which you know the legislature has just raised to $500,000. Can you do that? How many folks say, yes, this is okay? How many people say, no, this is not okay? The answer is, this is okay. This is permissible under Rule 4.1. 4.1 in the comments says that there's no general duty to inform the opposing party of facts, and there's no duty to inform the opposing party of statutory or case law. There's no duty, in other words, to disclose that the opposing counsel has misapplied the law or is wrong about the law in negotiations. There is one exception to this, but that occurs once litigation begins. If you're in litigation and the opposing side fails to cite controlling authority, and that controlling authority is directly adverse to your client, you've got to make that disclosure. But that is because of your duties under Rule 3.3. That is after litigation has begun. We're talking about before litigation. And we're talking now about duties owed to the court as opposed to duties owed to an opposing party or opposing counsel. Under those circumstances, if the opposing side has committed a serious boo-boo and has not cited controlling authority that is directly adverse to your client's position, you have an ethical duty to disclose that authority to the court. Hypothetical number 10. You are preparing for settlement negotiations with several lawyers who have been less than diligent in pursuing their clients' cases. You expect their adversaries to make mistakes, and you wonder about your right to remain silent in certain circumstances. Part A. May you remain silent if an adversary demands the full amount of what it understands to be your client's insurance coverage based upon statements that your client has made to the adversary before they hired you, but which your client has since admitted to you were incorrect. Would you have a duty to correct your opposing counsel's misapprehension about the coverage, the insurance coverage? How many people say, yes, I've got a duty to correct? that is the correct answer. Anytime the opposing side is misapprehending something because of an erroneous statement or a misstatement made by you or your client, there is going to be a duty to correct that misapprehension. In the cases of Tom cites, in some instances, the courts are going to set aside a settlement agreement if that disclosure has not been made. Yes?
It seems to me that would also be part of your duty to your own client, because it could void the settlement agreement under the doctrine of mistake.
Right. That's a good comment. You're putting your client at risk and greater expense in having an otherwise good settlement agreement declared null and void under the doctrine of mistake. And so, in the short term, while you might think that you're helping your client, in the long term, you've done the client a greater detriment. Part B. May you remain silent if an adversary demands the full amount of what it has determined to be the available insurance coverage, when you know there's an additional policy that the adversary could have discovered by checking available documents which have already been produced. But they just didn't catch it. They don't know there's an umbrella policy out there. Do you have a duty to inform them of the existence of that policy under Rule 4.1? Who says you do? Who says you don't? I side with the folks that say that you don't. The big difference here is that there's been no misstatement made by either you or the client, and that the information has been made available. It's just that the opposing counsel has failed to discover it. Again, just another practical consideration, though, and again from a professionalism standpoint, in making that decision, there are some collateral consequences, even if you're right. The collateral consequences being that the opposing side will attempt to have the settlement agreement set aside. They may not prevail, but the client would be put through the expense of having to defend that suit. And so I think that there needs to be a dialogue between you and your client as to which direction to go with this, so that they have a clear understanding that although you may be right, there may be some collateral consequences of having to defend a suit, albeit an unsuccessful one. May you remain silent when an adversary makes a $100,000 settlement demand, which you take as a clear indication that the other side must not know that your client also has a $1 million umbrella policy. Well, and you know, it's pretty much follows from what we've already discussed, that there would not be a disclosure duty. I hasten to add another caveat to the mix, that is you get a different result, of course, once you're in litigation and subject to the discovery rules that will require disclosure of insurance coverages. And so, again, you need to distinguish between pre-suit negotiations and post-suit negotiations. Now we turn to the subject of errors in the settlement agreement, and I'm going to, this is going to be the last hypothetical because we're approaching we're at 4 o'clock, so. You and your client have been furiously negotiating settlement documents with the other side in a big case, frequently working well into the early morning. Last night, you and the other side agreed to add a certain indemnity provision into the documents, but you realized this morning that the other side had not included the agreed-upon provision in the draft that they sent to you at 3 a.m. Must you tell the adversary of this oversight? How many people say yes? How many people say no? No one wants to say no. The answer is yes, absolutely. And the courts will set aside a settlement that has been consummated without this disclosure. The omission of the agreed term is a material fact that has to be disclosed under Rule 4.1. The omission of which, the failure to disclose that, and Rule 4.1 speaks to that there are times when the failure to disclose a material fact constitutes a misrepresentation. This is one of those circumstances where by not making that disclosure, you're behaving in a manner that is deceptive, and it's going to lead to having the agreement set aside and place you at risk of disciplinary exposure by the state bar. Do you have to advise your client of the adversary's oversight? Would you have to tell your client, look, let me tell you what happened here. The other side goofed and they didn't put the indemnity provision in. And your client says, great, so what? Let's go for it. Are you ethically obligated to communicate that and put yourself into that awkward position with your client? I haven't seen, Tom hadn't cited anything in the material. I haven't seen anything. He and I think that the answer is probably that you don't have to disclose that. And that is, the reason behind that is similar to the rationale in 1702 where a lawyer receives a misdirected communication, privileged communication, has very valuable information, and the opinion advises that you have to stop reading it, you have to notify the sender, destroy the document, and you are not ethically obligated to tell your client that you received that communication. The policy behind that is that it would undermine, what you would be able to do or expected to do, and create problems with the attorney-client relationship. I see that my time is about ended here, and the judges are going to speak next. I want to thank you very much for having me here. I hope some of this has been helpful. And don't forget when you leave to pick up the materials that have the answers to the questions. Tom worked very hard on it. I think these are a really good resource. And there's plenty of other questions that are addressed in those materials. Thank you so much, and enjoy the rest of the program.
So much. If you haven't met Jim before, it's great for you all to get to know him now. I'm sure you'll get to know him better during the reception. Jim, in my experience, is so kind and giving of his time. If you ever have questions, just call him up. He's very happy to take your calls. And Jim, on behalf of the VBA, we want to give you a small token of our appreciation. So thank you for being here.
Thank you, Jim.